Now the Cali drug cartel story. Yesterday, 3 former U.S. officials and 56 others were charged with being part of a big drug conspiracy. One of the 3 was Michael Abel, who ran the Justice Department's International Affairs Unit until 1984. He was, in fact, in charge of bringing cartel members to justice. For more on this story, we go to our regular legal analyst, Stuart Taylor. He's a senior writer for the magazines Legal Times and The American Lawyer. Stuart, the prosecutor in this thing, in announcing these indictments yesterday, called it, and I quote, the single most significant prosecution in history against the Cali Cartel. What does he mean?
Biggest in terms of number of defendants. There are about 60 defendants, 58 or 60 defendants. Biggest in terms of the amount of cocaine that this cartel has moved. The government tells us that some 80% of the cocaine in the United States is moved by the Cali Cartel, that they are larger in their impact here now, at least, than the Medellin cartel, which had a bigger name perhaps in the news a few years ago.
80% of all the cocaine that comes into the United States comes from this one cartel from Colombia. Is that what they say?
That is what the government says, and the people they've indicted include leaders of what's called in the indictment a faction of the cartel, who are still in Colombia and who presumably will stay in Colombia because Colombia will not extradite the leaders. But they also include dozens of other people, many of whom, some 20 some of whom, are now in custody in the United States, and of course it has several lawyers being indicted, including former Justice Department officials you mentioned.
All right, let's talk about them, because that's the one that's gotten the most attention. Tell us about Abel first. What is he accused of? What did he do when he worked for the U.S. government? What is he accused of doing now?
He was head of the Justice. He was a Justice Department official for many years, 17 years or so, I think. And at the end, in the early 80s,
was he a career man at the Justice?
A career man. Mm-hmm. And in the early 80s, he was head of the Office of International Affairs of the Criminal Division. And among the things he dealt with was extraditing suspects, including members of the Cali Cartel. He once, for example, signed a letter to Switzerland trying to extradite one member of the Cali Cartel who later became his client after he left the Justice Department. Now, he is not charged with anything relating to his Justice Department service. What he's charged with doing for the Cali Cartel in recent years that is alleged to be criminal is helping them cover up their activities, helping them thwart investigations by doing such things as getting people who are arrested members of the cartel to sign false sworn documents, knowingly false, the charge is, on the part of Mr. Abel.
And his capacity as a private lawyer after having left government service.
Yes, sir.
That's a very important
Yes, sir. He's not charged with anything relating to his government service, although it will certainly be relevant to the case. If there's a trial in this case, the prosecutors will certainly make hay out of the idea that this man is a turncoat, and they will have that opportunity. But on a formal basis, at least, none of the charges against him depend on his former government service.
Now, tell us about the other 2 former federal prosecutors.
One of them is named William. I'm sorry, I've got that wrong. There are so many lawyers indicted in this case, you need a list. One of them is named Donald Ferguson. He allegedly did some work with Mr. Abel, and like Mr. Abel, is charged on a variety of charges, most of which involve trying to help the cartel cover up what happened and trying to prevent arrested members of the cartel from fingering their superiors by such things as going to the jail, helping them get representation, paying for the representation on the condition that they not cooperate with prosecutors and the like. A third former federal prosecutor named Joel Rosenthal has already pled guilty in this case on charges of money laundering, which is another charge that the other lawyers are hit with, taking money they know is drug money and using it to pay lawyers, for example. And 2 other lawyers.
Excuse me, is that specific? Is that a crime? If a lawyer represents a criminal of any kind, in this case, people charged with drug trafficking, and their fees come, do they have to know that it came from illegal proceeds in order for it to be illegal for them to take it?
That's the critical thing. If you can prove that the lawyer knowingly took, for his fee or somebody else, knowingly took drug proceeds, technically at least.
Or proceeds from a bank robbery or a holdup or anything like that, right?
Yes. That is a prosecutable crime. It is very rarely prosecuted, and one reason it's very rarely prosecuted is that the prosecutors in the Justice Department recognize that defense lawyers are supposed to give the benefit of the doubt to their clients. So if the client has some kind of story that this is not drug money, many prosecutors will say, okay, I'm convinced, and they'll take the money. It's very rare to prosecute them, and the government certainly has the burden of proving that they knew it was drug money to make it stick.
And the government's case here is based on the idea, or on the premise, on the charges that these lawyers, there are other lawyers too besides these three involved, right? Weren't there three other lawyers also indicted for various offenses?
Three lawyers have, by my count, there are 4 lawyers who were indicted yesterday, or was unsealed yesterday, including 2 former Justice Department officials and 2 others, one of whom is a Colombian. And there are 3 other lawyers, for a total of 7, who have already pleaded guilty in this case, and 2 of them, in fact all of them, were associated with the lawyers who were indicted yesterday, including Mr. Abel.
And the point that the government's making is that what these lawyers did was separate and apart from anything they might have done as legitimate lawyering on behalf of their clients, correct?
Exactly. The government's position is if you want to go into court and try and make the base case for your client, that's fine. What they are charging these people with is being basically consigliaries to the criminal organization, of being the lawyers for the cartel, not the lawyers for individual defendants, and of trying to use their status as lawyers in order to persuade individual defendants to cover up and stonewall for the cartel, not to finger their superiors, not to cooperate with the government. Those are the charges, but there's a very fine line there as to what a lawyer can properly do and what he can't do, and these particular lawyers have very prominent members of the criminal defense bar who are defending them and who have been loudly accusing the government of waging a war against aggressive defense lawyers just to intimidate them.
And that's what, those statements have come out in the last 24 hours claiming that, correct?
Yes, and they've all been made, mostly been made by people like Roy Black, who defends Mr. Abel, by people like Albert Krieger, who defends one of the other lawyers, very prominent members of the bar. Although they're, of course, speaking for their own clients. What remains to be seen is whether the criminal defense bar nationally, people not involved in the case, will see this as a cause célèbre they want to jump on and say you can't attack defense lawyers like this, or will say, we'll wait and look at the evidence and say, well, maybe we don't want to ratify what they've done.
Stuart, hasn't this kind of thing arisen, the thing that, at least based on my very limited memory here, that this has arisen in the past mostly in organized crime cases, has it not, where lawyers who represent, quote, the mob, end quote, then later get indicted for crimes that they committed in addition to representation. Isn't that where it's come out before?
Yes, and there's been a smattering of that around the country, but in the Miami area, in Florida, it's a little bit of its own world, because that is the capital of cocaine importation. And there have been quite a number, I'd say over a dozen, maybe that's conservative, of lawyers prosecuted in the last decade or so in the Florida area for basically becoming co-conspirators with their clients, often on money laundering charges, because that's the easiest one for the government to prove, is to try and prove that this lawyer knew the money he took, particularly if he used it to pay another lawyer to represent another client, i.e. you're taking the lawyer from the head of the, money from the head of the organization to use it to represent some underling.
And then maybe the fees are very high and the money comes out again at the other end back to the client. Isn't that how usually money laundering works in these deals?
Yes, but with the lawyers are usually charged in money laundering cases either for passing the money to other lawyers to pay for the representation of underlings in the conspiracy, or for accepting the money themselves to represent someone in the conspiracy, knowing that it's drug money.
Now, who are the other people in general terms? You don't have to go through all the names.
Thank you.
Okay, but in general, who are these other people that amount to 60 who've been indicted in this thing?
There are about 4 at the top who are Colombians, Miguel Rodriguez Orjuela, I'll try that name, and his brother Gilberto, and a couple of other Colombians who are alleged to be the leaders of this faction of the cartel and the people who are running the organization. Then there are the lawyers, of course, and then there are dozens of players, Americans, Colombians, people who started businesses to import cocaine in container ships. As the indictment says, it was brought in with shipments of concrete posts, with shipments of okra and broccoli, with shipments of
through Miami, most of them through Miami?
Mostly through Miami. And they would set up various businesses to receive it, to transport it, to send it around, to launder the money, and it was a large enterprise, it's alleged, this cartel, with lots of spin-off operations in the United States that helped distribute the cocaine and launder the money. Most of the people are people who were who were managers and bit players and foot soldiers in those organizations.
Can you tell from reading the indictment, I understand how many pages, it's a huge thing, but can you tell from reading this thing and other sources how they broke this? Was this using undercover people or turncoats or what? How did they do this?
They got started with a particular arrest, I think, of a big distributor in Miami a few years ago, and I'm not sure how they got on to him, but they found a huge quantity of cocaine. And they did what they usually do. They arrested a bunch of people. They tried to get them to cooperate, to finger others. Some of them did. And there also were some searches and seizures. An unusual feature of this investigation is 5 law offices were searched last autumn, 4 in Miami and 1 in the United States, including the office of Michael Abell, who we spoke about earlier, for their records, presumably for the purpose of trying to find that they had the knowledge that this was drug money and that the statements they were making were false and that sort of thing.
So this was no surprise to anybody except the public, is that right? In other words, these guys knew they were under investigation.
Yes, and the people who were watching the investigation closely could see it coming, those searches. But it's one thing to search the office and to pick up whatever you can pick up, and then they had to go through the material under judicial supervision because of the problems with the attorney-client privilege. When you take a computer out of a law office, it's got all sorts of stuff about all sorts of clients on it, and including many clients who have nothing to do with the Cali Cartel. So it's a very delicate area. They went through this stuff under judicial supervision. The judge said, you can look at this, but you can't look at that. You can use this, but you can't use that. And ultimately, they figured they had enough to indict these people, although I'm sure there will be a furious defense saying that they don't have much at all.
In 2 areas. First, in the lawyering area, is this likely to turn out to be a big case?
I think it could be a big case in the lawyering area because there's been a low-grade war going on between a lot of people in the criminal defense bar, particularly drug defense lawyers, and the federal government, the prosecution, where there have been subpoenas for fee records because we think it's dirty money type thing, the government is saying, where there have been efforts to forfeit fees that they think are dirty money. There have been a handful of prosecutions. I think what this case does, it doesn't change the numbers all that much, although 7 lawyers is a lot. The prominence of some of the lawyers involved, the prominence of their defense lawyers, the publicity it's attracted, I think will make the defense bar decide whether they want to fight this battle against the Justice Department and make it a big PR counteroffensive, or whether they want to let these cases work out their course, whether some people want to say, hey, I represent criminal defendants, but I don't want to be associated with people who are accused as the house lawyers for the Cali Cartel.
Speaking of the Cali Cartel, that's the second. Is this likely to affect the supply of cocaine in the United States of America?
I have not heard it claimed by any of the government officials in this case that it will have any immediate effect or even any long-term effect, because most of the leaders of the cartel are in Colombia and they can't get them extradited. So unless the Colombian government changes its policy, nothing's going to change there, and they seem to be very good at lining up new people to arrest the old people who go off to prison in terms of their underlings.
Okay. Stuart, thank you very much.
Thank you.
Last week, the U.S. Attorney for Southern Florida announced a sweeping indictment against the Cali cocaine cartel that includes charges against 6 lawyers. 3 of the lawyers charged in the case are former federal prosecutors. 1 is a former senior member of the Justice Department. The lawyers are charged as co-conspirators in what the government says is an enterprise that brought 200 tons of cocaine to the United States. The legal community has been debating what this indictment means for the defense bar and whether the government has turned the corner in the war on drugs. Joining me now are criminal defense attorney Albert Krieger. His client, William Moran, is one of the lawyers charged in the case. Charles Rose, no relation, former chief of the Organized Crime Drug Task Force here in New York. David Chesnoff, a Las Vegas lawyer who has represented reputed members of the Cali Cartel. And from Washington, the former U.S. Attorney for the District of Columbia, Joseph DeGeneva. Welcome. It is a pleasure to have each of you here. There has been much, I'm sure, more talk in the legal community and in the defense bar, and especially in the drug bar, people who represent drug defendants in Miami about what has happened. Let me read to you as we begin this what the prosecutor said. Kendall B. Coffey, the U.S. Attorney for Southern Florida, called the case, quote, the single most significant prosecution in history against the Cali Cartel, which he said had been responsible for 80% of the cocaine imported to the United States since 1984. Mr. Coffey said Mr. Abel, one of the lawyers, and the other lawyers named in the indictment were part of a network of protection the cartel had engineered. And he goes on to say that in this case, lawyers somehow went over the boundary of representation. Mr. Krieger.
Sir, the propensity for people to pick up words, pick up catchphrases, and then utilize them was demonstrated in your opening remarks when you said something that referenced the lawyers who represent persons charged with violations of the Controlled Substances Act as being members of, quote, the drug bar. Mr. Coffey referred to the same group of lawyers, if there is in fact such a group, as members of the white powder bar.
Yeah. Which is a term of art used in Miami, is it not?
Well, I've only lived there 25 years, and I never heard of it until I saw it in the New York Times, quoting Mr. Coffey. I'm sure Mr. Coffey, who happens to be a fine gentleman, never came across the term because he was never a criminal defense lawyer. So I don't know where he would have run into that kind of phrase. Maybe the agents use it, maybe some investigators use it, but it is not a phrase with which any of us are truly familiar.
Then let me ask this question, because I want to get a lot from you before we get started on this. Are there a group of attorneys, members of the defense bar in Miami, who have represented and who represent a lot of people who've been charged with drug-related offenses?
Yes.
The importation of drugs.
That is so, and that is a direct result of what is being prosecuted. If there were gambling cases being prosecuted, then there would be lawyers representing many people charged with gambling crimes. If there were a rash of bank robberies, the same would apply.
My point is that there are a number of people who do this, attorneys who've gained a reputation and therefore frequently do a number of these cases. Here is my question, though. What is your client charged with? What is the bill of indictment against your client, specifically an attorney who is well known in Miami?
The indictment against Bill covers two separate RICO charges, a substantive RICO charge and a conspiracy under the RICO Act, narcotics conspiracy, and numerous money laundering counts. The exposure that he faces is life in prison. The scope of the indictment is one that has filled much of the defense bar with more than passing fear.
Because?
Because the acts of the functioning criminal defense lawyer can be given a spin, given an interpretation that result in a prosecution. And if I can use it as an example, an instance, all right? Let us suppose that Gilberto Rodriguez Orjuela, who was just arrested.
The man is charged with being the head of the cartel.
That's right. He's also named in the indictment. Were to have called me immediately after his arrest and said, Mr. Krieger, I would like for you to represent me. Okay? Should I accept the retainer? That's a matter of absolute personal choice, whether I would decide to represent him, not decide to represent him. It might be determined by whether the rent is due, or it might be determined by something in the indictment that triggers a little bit of interest in me. Under any circumstances, I accept retention. At that point, considering what the President of the United States has said, considering what the Deputy Attorney General has said, considering what Mr. Coffey has said, I have been put on more than notice that my prospective client, or my client if it has come to pass, is a notorious figure and a probable boss, leader chieftain in a massive criminal conspiracy. Okay? Now, I accept money from him. Does that make me a party in this narcotics
I don't know if
organization?
anybody is saying it does. I
Well,
know of
let's
no
take it
one
a little
that's making
further.
that point.
No,
Are
they're
they?
not, but they're falling into it.
All right.
Because it is my duty, responsibility, and obligation under the Constitution of the United States to represent him in the best fashion that I can bring to bear.
Within,
Right? We don't have to come to that at the moment, because as a predicate to everything that I say about representation, it is within legal and ethical borders. I will, because I'm a practical person, recognize the fact that I may well be aiding and abetting the Cali Cartel in my vigorous representation of him, and that it would benefit the Cali Cartel if I'm successful in obtaining his acquittal. And I recognize further that if he is acquitted, that the Cali Cartel may not only have derived comfort in that a chieftain is acquitted, but it may further their activities.
all right, let me, before we go any further, Joe DeGenova, who I've known for a long time, tell me what you think of this as a former prosecutor, and do you think that Mr. Krieger is building a straw man here?
Well, I think the case is a fascinating one. I spent some of today reading the 162-page indictment, and it's a monstrous document which accuses these lawyers, literally, of having crossed the line. It says that they submitted false affidavits knowingly, that they assisted in the paying of money to hush up arrested members of the cartel so that they wouldn't cooperate. It says that they identified an informant who was then targeted for murder. It says that they knowingly submitted false affidavits. It says that they submitted affidavits to prohibit forfeiture of things. What I see in this indictment is this. If what the indictment says is true, and that's a very big if, then clearly these lawyers, if they knowingly and willfully understood that they were attempting to obstruct the criminal process, to aid and abet, not in the way Albert was saying aid and abetting, by simply being vigorous, but if they knowingly did these things, then they clearly have violated the law. But the question is, what kind of evidence does the government have that they did this? And who are the witnesses that the government is going to use against them? Obviously, two of the most important witnesses the government now has at its disposal are two of the other lawyers who were working with two of these lawyers. And that's going to be a very interesting part of this case. Who are going to be the witnesses, and will they be believable?
I know you want to get back in, David, and I want to get Charles in, and I want to get David. Tell me what, Albert, I'm sorry. Tell me what you think about what the issue joined so far.
What's happening to the lawyers in Miami is nothing more than an extension of what's been happening to criminal defense lawyers throughout the country who vigorously defend people.
But isn't there a difference, as Joe just pointed out, between vigorous defense and doing the things that are in the indictment? If the lawyers did the things that's in the indictment, you would agree, would you not, that they ought to be indicted?
Absolutely not.
You would not?
Telling your client that someone is a potential witness against you, an informant against you.
Faking affidavits?
If faking affidavits can be proven, that may be a crime.
Okay.
But the suggestion, however, that you are not allowed to tell your own client that there is someone who is going to testify against you flies in the face of
but
the
you're picking out one, aren't
well,
you?
but it's a good one. It flies in the face of the confrontation clause, the ability to confront your accusers. If you cannot tell your own client because your own client is characterized by the government as being the kind of person who might react the wrong way to learning that someone is an informant against him, that's a real problem. And to extend it to a crime for the lawyer to do that is a real problem. And it's very hypocritical for the government to be attacking defense lawyers for trying to ferret out informants when the very same government relies on informants who are probably more reprehensible than the people they're trying to put in jail. They routinely reward the most reprehensible people with freedom and money. Murderers, rapists, extortionists, arsonists, and to have a U.S. attorney or a Justice Department spokesman somehow attack the moral fiber of the defense bar for doing their job, that's where it gets just carried away. That's where it's wrong. The idea of helping someone get bail, traditionally we were allowed to have bail in this country. They enacted the Bail Reform Act, which restricted people's rights to bail, left it up to a judge to decide if someone was a flight risk. After restricting people's civil liberties to that extent, making us go through an entire process with a judge to decide that, they now want to be critical of the defense lawyer for effectively representing his client and getting him out on bail.
Charles Rose, former prosecutor.
Now defense lawyer. I'm fascinated that, David, you could sit and actually say that falsifying an affidavit and submitting that affidavit to a court may be a crime. It is a crime. There's absolutely no possible way it may be a crime. And again, if it's true, the real problem here is these lawyers are not representing their clients. They're representing the Cali Cartel. Their loyalty, and I'm not, again, if the allegations are true in the indictment, what they're charged with is not representing an individual client. There's absolutely nothing wrong with telling a client that you believe or suspect that a particular individual is someone who will testify against you. What's wrong is telling your client that an individual is going to testify you, and then getting on the next telephone and calling the head of the Cali Cartel and making sure the Cali Cartel head knows that an individual is going to testify against you, knowing full well that that cartel will do everything in its power to eliminate that person. The problem with, and these lawyers, and I know one of them and worked with one of them, but this is not just Miami. This is in New York too. I can tell you time after time when people from not only the cartel, be it Cali or Medellin or the Lucchese family or the Gambino crime family, people would come to us and say, I want to cooperate. Don't tell my lawyer. I can't tell my lawyer, because if I tell my lawyer, I'm in danger. Now, there's two points to that. That doesn't necessarily mean the lawyer is in cahoots with the organization. But there are lawyers in this town and in other towns who refuse to represent people who will cooperate with the government. Right. That's their decision.
I'm one of them. I won't represent anybody.
Well, then you're not representing your client.
Because I don't think it's morally a proper course of action. That's my own moral perspective. I refuse to do it. I tell people when they come to my office that I don't represent people who cooperate. If they want to make the choice to stay with our office, they understand that. That doesn't mean to say that when it's proposed, I don't present it to them and suggest to them that they acquire counsel that will assist them to do that, but I just won't do that. And to suggest somehow that a client's interests are somehow different than other people's interests. For example, some people might not want to cooperate, knowing the consequences, knowing they may go to jail for an extended period of time, balanced against the possibility of having a capable lawyer actually win their case. The government wants you to promote this cooperation, and that's not our job. That's their job.
Well, we're getting off what is really the point, and I think Joe is confronting it. If we assume that the allegations in the indictment are true, then there are certain discrete acts of obstruction of justice and or money laundering that the government may be in a position to prove. Those specific acts are crimes, and nobody can quarrel with that type of statement. But to take a few criminal acts and throw them in the middle of a Cali Cartel indictment that runs, according to the allegations there, some 12 years, takes away even the ghost of a fair trial from these particular lawyers.
Oh, stop right there. Do you former prosecutors have any problem with that he's making a valid point, to throw these indictments in with overall series of indictments of members of the Cali Cartel is perhaps prejudicial?
It may, at first blush, it might seem prejudicial. I mean, I'll tell you the truth. I don't know why. They only went back to 1985. I could have gone back to 1977 with this Cali Cartel indictment.
Yeah. Well, Joe, does Albert make a good point here now on this?
Of course he does, and that's going to be one of the very interesting issues in this case, is whether or not, I'm sure there are going to be motions for severance. that these lawyers should be tried separately, that they're going to be, that it's exactly what Albert says, which is that there is so much evidence against the other people that it's going to spill over and it's going to taint these lawyers. And again, the question is, what is the nature and quality of the evidence against these lawyers? Who are the witnesses? What types of deals have they been made by the government?
All right, well, let me ask you a question. Would the U.S. attorney, as far as you know, have brought these indictments if they didn't feel like they had a very strong case?
Well, under the Justice Department guidelines, they are not permitted to bring any indictment against any citizen unless they have a good faith reason to believe that they have enough evidence to convince a jury beyond a reasonable doubt. Now, I am assuming good faith on the part of the government here, and I can't assume anything else. But remember, the government can establish these cases circumstantially. It may be able to say by inference and even by innuendo that they can infer that lawyers did certain things for some reasons. But it is apparent from reading the indictment that they have direct testimony from some witnesses that lawyers did certain things knowingly. And the question will be, are those accusers and witnesses believable? This is going to be a case about credibility. And that's going to be one of the reasons that I'm sure Albert and others are going to seek severances.
Yeah, I mean, I just think that it seems to me that the point Albert makes is that without the severance, it can appear that the attorneys are being charged with the crimes of their clients.
Well, they are being charged
no
with...
question
no,
about
but they
that.
are literally being charged with the crimes of their clients.
Let me throw in a fact here. The government announced in open court that it anticipated the trial will take from 6 to 8 months. Now, this isn't a California state trial. This is a trial in front of an experienced federal judge. And if they are talking 6 to 8 months, the amount of evidence, we're talking in tens of thousands of pages of transcript and probably well over 100 witnesses. Now, the amount of evidence in a fashion most favorable to the government that involves the lawyers would probably take 2 weeks if there was foot dragging to get before the jury. So the lawyers would have to sit with concrete posts full of cocaine with which they didn't have anything to do. The indictment is specifically crafted to exclude the lawyers from any activity regarding importation or distribution of cocaine. So they are literally put off to one side, but they're going to have to sit there in a snowstorm, 200 tons of cocaine. And then we're supposed to stand in front of a jury and say, forget about the cocaine. Just judge these lawyers on the specific little bit of evidence that was introduced against them. By the very structure of the indictment, they should be separately handled.
But are you suggesting the prosecution did it this way, they did it this way because they wanted to have that additional cloak to somehow make more likelihood the possibility of conviction of members of the defense bar, to scare members of the defense bar in defending people accused of...
No, I don't buy into that theory as such. I don't believe that there are people sitting in the Justice Department or in Mr. Coffey's office who have engaged in an actual agreement, a conspiracy to destroy the defense bar.
Yeah.
I don't believe that for a
but
moment.
Suppose you don't do that. Suppose you say it this way. We've got a case in which lawyers have gone over the bounds in terms of representing. It is not vigorous. This is the committing of crimes, and we need to send a signal, and we need to... There have been crimes committed here, and we ought to prosecute them. We ought to get on with it because it goes to the heart of our
I have no problems with that. If there is the good faith belief in the crimes having been committed, then it is the responsibility, the duty, and the obligation of the prosecution to bring actions against alleged lawbreakers. But are you saying
that on the part of the feds in this case there's not a good faith belief in the crimes having been committed?
If he's not prepared to say it, I am. I think this is part of an overall pattern that has developed over the last several years of targeting lawyers who vigorously defend people in very, very unpopular cases involving either organized crime, controlled substances, or whatever the cause celeb for the Justice
Towards
Department.
what ends?
Towards the end of stopping them from representing them.
So that the best lawyers will not be available? So Roy Black and Albert Krieger and people like that will not be available to defend organized crime figures and drug cartel accused members?
Mr. Rose, I've spent the last 2 years representing lawyer after lawyer who vigorously fight specific cases that are considered high profile. It does have a chilling effect. The lawyer does not get calls for business. The lawyer is shunned by other lawyers. The government is attempting to stop these people from being involved. I mean, just recently, we talked about good faith. I don't believe there's good faith. They just prosecuted a wonderful lawyer by the name of Patrick Hallinan in the District of Nevada, who was alleged to be an advisor and doing similar things to these people to a major marijuana smuggling operation. Tons and tons of marijuana from the Orient and from Mexico. And he was acquitted in a brief period of time after the U.S. government dragged his name through the mud for over 2 years.
David makes a very important point. David makes a very important point, and that case is very interesting because it's actually the point I'm making. Everything in this case about the attorneys depends upon who the witnesses are against them. In that Hallinan case, the only people testifying against him were actual participants in the drug conspiracy. I think you might call them scumbags by any definite standard. The jury acquitted him almost immediately. And the government has to be very careful about the way it brings these cases. Let us make it very clear. Lawyers are not above the law, and if they cross that line, they should be indicted. And Albert said that. But the problem is they've got to make doggone sure that these cases are solid, and that the witnesses against these attorneys are not just the lowlifes of this world. Because, let me tell you something, the government suffers a great defeat when it charges somebody like a Hallinan or another group of lawyers and then loses the case. There's much to be lost for the government if they don't have all the apples in this cart in this case. Because remember, when you look at some of the things they're accused of, again, I want to make David's point again, allowing payments and subsistence allowance and attorney's fees, that's not per se illegal. That's perfectly proper. For example, getting bail for someone is perfectly proper. Warning that there are indictments coming, perfectly proper. Briefing sessions on the investigative status, there's nothing wrong with that. The government is going to have to show that the lawyers did these otherwise legal activities with criminal intent designed to have the enterprise succeed. That is a very difficult burden, and they better have some damned good witnesses.
Albert.
Well, there is no question, but Joe is 100% correct in how he sets it out. I repeat what I said. There is no high-level conspiracy so far as I can see or observe. Are there overzealous prosecutors? You can rest assured that there are. Are there agents who have lost their sense of balance and believe that defense lawyers are nothing else, to use a Washington word, scum? You know.
Well, we have a lot of politicians here, so it's an easy word to come up with.
That is so. However, what we have to face up to is that a spin can be put on legitimate legal defense. And as a result of that, lawyers are prosecuted. If a lawyer is prosecuted, then lawyers who are not prosecuted are going to look over their shoulder. And the last thing in the world that this country needs is a craven criminal defense bar, a frightened criminal defense bar, or a criminal defense bar that is so concerned about its own position within our society that it forgets that it owes to its client a total dedication. That is the danger that we have in this indictment. Not that they are specifically saying they're going to put lawyers out of business, but lawyers may be put out of business as a result of an indictment such as this.
Charlie.
And before, a specific example of a specific case in Nevada was given to someone who was acquitted, and as if that means anything. I mean, I don't know whether that person did or didn't do what he was accused of. I know he was not proven beyond a reasonable doubt. But you can't cite individual cases like that, because I can counter by naming half a dozen lawyers who've been convicted, either after trial or pleaded guilty to drug trafficking. The problem here with these lawyers is is that they have crossed the line.
How do you know they've crossed the line?
Because the line is not all the times gray. Even, you know, Joe DeGenova, who I love and admire and used to work for and worked for his wife, you know, gave a litany of things that were not wrong. Well, I would disagree in some of them. Some of them are clearly not wrong. But, for example, debriefing sessions. Well, if the head of the Cali Cartel called me and said, I'd like you to come down to Colombia, and I'd like you to give me a briefing on all the Cali cases that are going on around the country, and I want to gather all the evidence, and I'd like to retain you as a lawyer, for example, and I'd like you to analyze all that, use your expertise as 17 years a prosecutor, or however many years some of these prosecutors had, and I want you to tell me everything there is, so therefore I could run my criminal organization better without chance of being caught. That, to me, is crossing the line.
Drop out the so therefore, and then what's your
What
conclusion?
else would he be wanting me to debrief him on? So, for his interest?
I'm out of time, so go ahead real quick.
Look what they did to do this. They invaded the sanctity of the lawyer's office. They wiretapped the lawyer. They seized his files, which may contain incriminating evidence against his own client. And for what end? To end the drugs being brought into the United States? They can forget it. They've had their war on drugs. It has been completely unsuccessful.
Let me just ask this question, because it's the kind of question I like. If, in fact, the head of the Cali Cartel did call you, would you have accepted the case? Not whether you needed it or whether you needed the money or you had a mortgage to pay. Would you have accepted the case?
Probably.
Probably. You would not?
No.
You would?
I would welcome it.
You would, because it's a great case, because it's a lot of money, because all which is in the American spirit. But
could fight the government.
All right, to fight the government. Joe, would you defend the head of the Cali Cartel?
Let me tell you something. I've thought about this an awful lot, and I'll tell you what you could do. I would take a representation like that on the understanding that the head of the Cali Cartel would be willing to cut a deal with the United States government and provide information about all the people who really were cooperating with his organization in the United States, and see if we could work out something that would help both countries.
Is that the only circumstance, that unlikely deal you would make?
Oh, I think probably that it wouldn't be the kind of case that anybody would come to me on. But I would certainly consider doing something that would enable that person to get out of the business and destroy the enterprise and assist the United States government and be able to do something for both countries.
As I've said, this is a fascinating story, because not only do you have the series of indictments against the Cali Cartel, including the head of that cartel, you also have some of the best members of the defense bar now involved, representing attorneys who were representing people accused of being members of the Cali Cartel or involved with them. So is it a fascinating case, much talked about in legal circles. Thank all of you for joining me.